So welcome back. It is my privilege to introduce our keynote speaker today, Professor Jack Coe. Jack is Professor of Law and the Faculty Director of the LLM program in International Commercial Arbitration at Pepperdine Law School. Jack is an elected member of the American Law Institute, and he has served as an associate reporter on the ALI Restatement of the law of international commercial and investment arbitration. And as I mentioned at the outset, that was a 12-year project, and the final draft was just approved by the American Law Institute in May. Jack is also a member of the U.S. State Department's Advisory Group on Private International Law. He has served as an arbitrator in cases under several rules, including the American Arbitration Association rules, the ICDR rules, the ICC rules, and the UNCITRAL rules, both as a party-appointed and as an institutionally designated arbitrator. He also consults with parties in commercial and investor-state arbitrations and has submitted expert opinions on international law. Please join me in giving a warm welcome to Professor Coe.
Am I being heard? Thank you, John, for that introduction. I am delighted and honored to be here today. Grateful to the organizers for inviting me. I'm confident that they did so because I know the rules about giving luncheon speeches. The first one, of course, is borrowed from Hippocrates, first do no harm, which in this context means don't do anything to interrupt the normal digestive processes that you're going through right now. Given that I think that means politics is off the table, I will talk about the restatement John referenced on, I'll say the title, long as it is, one final time, International Commercial and Investor State Arbitration, for which, as John said, I have been one of the 4 reporters. You'll probably be familiar with the others by reputation, at least. The chief reporter, our tireless leader, is George Berman at Columbia Law School. Other associate reporters besides myself are Professor Catherine Rogers and Chris Drohozel. So as John mentioned, the major headline now associated with that project is that as of May 20th, the membership of the ALI voted to approve it officially. That is to say, we're open for business in the sense that its principal audience, judges and those hoping to persuade judges, may rely on it without fear that it will further evolve, and with the confidence that the black letter and the comments have been vetted through the full ALI peer process. And having been so approved, the black letter and the comments are the official position of the American Law Institute. So as John mentioned, and well known to those of you who've actively followed the project, it took 12 years to complete. And the reporters encounter 2 kinds of reactions to this gestation period. Those not familiar with the ALI process say, of course, what took you so long? And then those who are active in the ALI compliment us on getting so much done in such a short period of time. That's not a knock on the ALI, far from it. It's rather just to underscore that the ALI peer review process really separates its work from most other producers of soft law, I think. The problem is, of course, that I told my wife it would take 6 years at most. And I thought I was being conservative. I thought I would come in under budget, so to speak. So in this connection, it was nice when I heard at the annual meeting Justice Kennedy liken restatements to Blackstone's commentaries, which he credited with saving the common law by making it more accessible. So hoping to restore my wife's favor, I relayed this indirect compliment of Justice Kennedy. And her reaction was to ask whether Blackstone, too, had lied to his wife about how long the project would take. So the second rule of luncheon remarks is that one should use props only sparingly. So I hope I will be forgiven for waving this around a little bit. I do so to dispel any notion that what we're talking about is a breezy romp through a few basic legal questions. It's 950 pages, not including appendices. So strange as it seems, given this tome, the scope of the project was actually carefully circumscribed. The title tells much of the story. The mandate was to focus on international, commercial, and investor state, which means that we didn't focus on certain other things. Because of FAA's one-size-fits-all orientation, of course, there are many important cases arising out of domestic disputes which we couldn't ignore, especially those decided by the Supreme Court. But we tried hard to resist to weigh in on, albeit important questions raised, for example, by consumer arbitration or employment arbitration, which we agreed was beyond our mandate. So the restatement consists of 5 chapters. The first chapter, among other elements, contains 58 definitions that bear on the restatement. Now, those of you who know restatements know that's unusual for there to be definitions, but in our case, they proved to be analytically quite useful for unifying our usage and disciplining, in a way, our thinking. And we're told by certain newcomers to the field that they really help orient them. Many of the definitions are, after all, quite basic. For example, what is arbitration? But even the basic definitions have these analytical ripple effects that cause us to really think and rethink the definitions, and perhaps to refine them as we go, which is why I say they sort of perform a disciplinary function. Take, for example, the definition of arbitral award. The essence of the definition is that, quote, it is a decision by an arbitral tribunal that sets forth the final and binding determination on the merits of a claim, defense, or issue, end quote. That's the heart of it. Decision by an arbitral tribunal that sets forth the final and binding determination on the merits of a claim, defense, or issue. So far, so good. But what about awards that decide fewer than all of the issues? Well, that was a pretty easy one. American courts either should or have been enforcing awards that decide, for example, liability as a separate bifurcated aspect of the proceeding. So we added an appropriate definition, partial awards. Importantly, our FAA-based system, the denomination award, means the decision could be subject to both a request before a court to recognize it, but also a vacatur action. So those possibilities are baked into the definition of award. You call something an award, that has implications for access to courts. So the more difficult question was whether we should include in the definition of partial award, or awards generally, grants by tribunals of interim measures. That is, non-final remedies designed to preserve the status quo or otherwise protect the arbitral process. The problem is they're not final in the usual sense, at least not in the sense of the partial award that I just described to you. Interim measures can be withdrawn and modified by the tribunal, and they typically are not thought of creating res judicata effects. So can we really call them awards? At the same time, recall, however, that unlike the UNCITRAL model law, the FAA has no regime for court enforcement of arbitral decisions that are not awards. Yet courts have been calling them awards in order to justify enforcing them off and on for decades. And our advisors certainly thought that kind of support was to be encouraged. So this dialectic produced ultimately a rule that we fleshed out in the definition and also elaborated on in the so-called comments, that indeed an interim measure is rebuttably presumed to be an award, but we invited the courts to examine all the circumstances surrounding its issuance to determine whether the presumption had been rebutted. For example, was it prepared in the manner of an award? Was it accompanied by reasons? Was it signed by all the arbitrators? What do we know about what the rules say about what an award is supposed to look like? It hasn't gone through ICC scrutiny and so on. And of course, then there's this other knock-on question after we think we've gone through this rather difficult one. What about then the work of emergency arbitrators? Right? These are arbitrators that are assigned to hold the fort before the tribunal is impaneled and often to issue urgent measures of some kind. Are those also awards? I'm going to leave that as a cliffhanger, give us something to talk about during coffee. The first chapter also introduces some foundational principles such as the role of party autonomy, the importance of the seat of arbitration, and how the three conventions apply, their requirements and so on. Also suggests an approach as to how federal law preempts state law. That is the test for that, since it's not fully preemptive, it's only partially preemptive. The second chapter deals with enforcement by courts of international agreements to arbitrate, principally through, in the United States, stays or dismissals, but also through orders to compel arbitration. Now, one function of that chapter is to identify grounds, or if you prefer, defenses to enforcement of putative arbitration agreements. Such defenses are contemplated by the language in the New York Convention that allows courts not to enforce written arbitration agreements if they are, quote, null and void, inoperative, or incapable of being performed. That's a treaty phrase of art that basically encompasses contract defenses, such as that the arbitration agreement never came into being or for some reason has become invalid. The third chapter addresses involvement of courts once the arbitration is underway. There we discourage courts from becoming involved just because they're asked to, but also identify several ways in which the courts can support arbitration, such as in appropriate circumstances granting provisional relief or assisting an international tribunal in gathering evidence. The chapter also touches on arbitral immunity and certain other matters styled as ancillary issues. Chapter 4, in turn, addresses the role of courts in post-award settings. So this is principally in connection with the court's treaty obligations to recognize and enforce certain arbitral awards and the grounds upon which they might refuse to do so, typically associated with the New York Convention's Article 5. The chapter also addresses vacatur of awards rendered in the United States, or at least international awards rendered in the United States. Those of you from outside the United States know this is annulment or set aside, but we're talking about vacatur. Now, one of the complicating factors we had to deal with through the project was that the United States, when ratifying the New York Convention, extended the convention's reach not only to awards issued in other New York Convention countries, but also to international commercial awards rendered in the United States. So the non-controversial impact of this was to create federal court jurisdiction where there might not otherwise be such jurisdiction. So more controversial was whether the manner in which the FAA implemented, in terms of language and structure, the convention, required courts to depart from the usual grounds for vacatur ordinarily applicable to awards issued in the United States. Those are found in FAA Section 10. Under one interpretation, anyway, those Section 10 grounds are replaced by the grounds for non-enforcement found in Article 5 of the New York Convention. Now, again, we're talking about international awards issued in the United States. At least linguistically, the two sets of grounds are noticeably different. Most U.S. jurisdictions had continued to apply Section 10. If an award was issued in the United States, then Section 10 is the test for whether or not it becomes vacated or, in turn, confirmed. But one circuit, indeed, had adopted the notion that the convention grounds should replace Section 10 grounds. And interestingly, that view has some advantages, though it's a distinct minority position. And it was more than actively considered by us, the reporters, and by our dozens of advisors. I'm tempted to go further, but I think if I did, I would violate the first rule, which is to do no harm. Suffice to say that in the end we adopted the majority rule, which is a relief to a lot of folks. Section 10 provides the grounds for vacatur. And even having done so with the agreement of everybody, at the annual meeting where we were approved unanimously, there was a colleague or two queuing at the microphone to ask us one more time to reconsider our view on this point. Among other things, this reminds us that U.S. practice under the Convention is a function not only of the treaty text itself, but also of the legislation that implements it, that is, particularly Chapter 2 of the Federal Arbitration Act. The final restatement chapter is devoted to the court's role with respect to investor-state arbitration. Perhaps a central message here to courts is that ICSID convention awards are not treated like other awards. For example, as a matter of treaty obligation, courts may not vacate ICSID convention awards, and when asked to enforce them, cannot decline to do so on grounds such as those one would find in Article 5 of the New York Convention. That is, not even public policy in principle is available to decline enforcement of the monetary component of an ICSID convention award. So those of you who are watching global developments here know that there's some things going on in the European Union that might call some of these basic precepts into question. And I think that's a wonderful topic, but it's a topic for another day. I should note that the reporters did not undertake to set out substantive investment law. That is to say, we didn't undertake to say what fair and equitable treatment requires of the host state, and so on. And relatedly, throughout the entire restatement, we avoided talking about arbitral procedure. So perhaps in a reporter's note, you'll find a reference to the IBA rules. And I'm sorry to say there's no reference to the Prague rules yet. That'll be through the revision. So we kept away from arbitral procedure because, frankly, that's not what courts need to know about, except to the extent it may bear on the enforceability of the award by virtue of some dire breach of due process. Especially for our colleagues from outside the United States, I should mention one other misconception, which to some extent I had for a while. And it is that restatements perhaps are ill-named, a sort of misnomer. They are not merely an inventory of the majority views expressed by American courts. The method is rather more nuanced than that. Subject to various levels of peer review, as I've suggested, the reporters may propose minority positions or variations of existing rules. I'll give you one example. There's this notion found in some cases that a court should not compel arbitration to take place in a foreign seat unless the seat is a country that is a party to the New York Convention. In fact, the Convention makes no such reciprocity requirement, and obviously, or presumably, the notion was borrowed from practice with respect to foreign arbitral awards, concerning which there is, of course, a reciprocity requirement. In any event, the reporters had no hesitation in sponsoring the view that there is no reciprocity requirement that affects the enforcement of arbitration agreements, despite the assertions, multiple assertions in several courts. Now, several other places where the restatement decides to qualify or reject a rule popular among courts, but we never did so lightly. And of necessity, we took as fully authoritative and binding U.S. Supreme Court authority, the text of the FAA, and the text of the principal conventions with which we were dealing. Those were givens, anchors, immutable foundations that we couldn't do anything with, as I say, for better or worse. I'll close by mentioning another misconception, one that I had before the process started. In my earlier work, I used to cite rather indiscriminately the three layers of restatement text. So there's the black letter, followed by comments, followed by reporter's notes. And I came to find out technically, somewhat with disappointment, that only the black letter and the comments present or represent ALI official positions. The reporter's notes, by contrast, are merely private explanations of the reporters about the support for how they developed the rules and the pros and cons. And in our case, it was a place to provide somewhat lavish, given the girth of this, explanations, background, discussion. In the end, the volume I've shown you strikes my students as perhaps somewhat more than they care to know about the topic. To that I answer, well, in fact, the black letter only takes up 64 pages. So in that sense, it is indeed a breezy read. And we, the reporters, hope that you look beyond the black letter. I'm at the point now, John, that I invoke the third rule, which is related to the first rule, which is not to go on too long. And so I think I will stop there, except to invite any questions that there might be about our project or about whether I'm getting along with my wife these days or anything else that's on your mind. Thank you very much for your attention. Sir.
As you went through the project, did you find many examples where the Supreme Court has left conflicts among the circuits? I know, for example, in Section 10, they've left us with confusion as to manifest disregard. They haven't addressed evident partiality since 1968. The circuits are debating what confirm means in Chapter 2 of the Convention.
Absolutely.
Are there any more that you have to?
Well, it was, of course, our job to keep track of that very carefully, because once the Supreme Court had come down on something, we were obliged to implement it to the extent we could. And so all of the things you mentioned are on our radar, or were on our radar. It's a point now at which the project is done where we have to sort of turn a blind eye to it. But in fact, the manifest disregard of the law, the closest we could come to dealing with that is to cabinet in a way we thought that it would end up in just being another way of saying one of the grounds under FAA 10, for example, and not something freestanding. And also the debate about which set of grounds apply, New York Convention grounds for vacatur versus Section 10 grounds. We do say in there, and with some support, that when you stand back and look at them, although textually they're quite different, there wouldn't be that many cases that would differ depending on which of the tests you applied under most approaches. But yes, there are probably a list of lots of things. While I'm answering your question, let me mention one more. It was raised this morning, and that's the question left unanswered about whether indeed competence provisions and institutional rules necessarily constitute a clear and unmistakable delegation. The reporters, somewhat going out on a limb and contrary to what some courts have gleefully proceeded with, suggest ain't necessarily so. I mean, clear and unmistakable is the test, and some of these rules are replicating pre-Kaplan descriptions of the run-of-the-mill competence doctrine, which really just says to tribunals, you may go forward even though your jurisdiction has been, doesn't say anything about the level of review that the award will receive on the back end, or for that matter, jurisdictional issues on the front end. So I believe when the Shine case got sent back down, that wasn't necessarily decided. I think there was language suggesting they might want to take a look at it. Long answer, and I apologize for that.
Appreciate it.
Yeah. It's the professor in me.
Any more questions?
I think I cured them of any questions.
Thank you, Jack.
Oh.
Jack, can you hold it up again?
Yes.
It's an impressive achievement. Longer than the Mueller report, I think.
Yeah.
Actually, I don't know that. Could well be.
Yeah. It's part 1 and part 2.
Yes. But I will say this, the restatement has already, when there were drafts of it circulating before it was made final, it's already been cited in cases, including by the Supreme Court. I know Justice Roberts has cited to it. So it really is an impressive achievement, Jack, that you and your colleagues have done this.
Thank you.
And you should be very proud.
Well, as I say, tell that to my wife, but...
yes, I'll give her a call.
Yeah. No, and in fact, the good news is the four of us are still getting along very well and are actually a little sad that the project's over because we're having so much fun arguing with each other over how it should come out.
Just pick another topic, you know.
Well, you know, don't tempt me. But to the four of us worked very hard and had the laboring oar, but understand the importance of the advisors. I mean, we had two groups of advisors at the LI, those who were called advisors, and then those self-selecting members who religiously came to sessions where they could be billing their time doing something else for a day and would say, you know, you could improve this draft by doing that. That rule doesn't sit well with us because it seems inconsistent with this other thing. And then genuine debates about things that they cared about in their practical life that mattered to them. And in theory, and most of the time in practice, they were supposed to leave their clients at the door. Now, it didn't always happen, but at least they were fully disclosing, saying, well, I'm in a case right now where this is the key issue, but very helpful to have a room full of energetic people digging in on your work. Thank you for that.
Thank you, Jack. Thank you.